Hello, I'm Stephen Sheldon with SMS Capital Management. In an effort to help you make sound and practical decisions when it comes to managing your wealth, I'm conducting a series of short video interviews with other professionals on a variety of topics that may impact you. So we're here today with Todd Slobin, who is a board-certified attorney specializing in labor and employment law. Welcome, Todd.
Thank you.
We're going to talk to Todd about legal issues related to employment with a company. So Todd, let's start off with, when you're starting a new position, what are some of the agreements or documents they would expect you to review and sign when you're starting a new position?
Sure. When you're starting a new company, you may be asked to sign a employment law or employment handbook, arbitration agreement, commission agreement. You might be presented with vacation policies, things like that. And sometimes you actually may be presented with an employment agreement.
Okay, and in an employment agreement, what would be the key features or stipulations that one would expect to see in that?
An employment agreement is what I refer to as like an instruction manual.
Mm-hmm.
It tells you what to do and what not to do, and how your world's going to work if things don't work out. So things that may be contained in that employment agreement are going to be how you're paid, what your job description is, and then basically what will happen if things don't work out. And there also may be non-compete agreements in there too.
So in an employment agreement, lots of different provisions in there, but when you're talking to people or calling you seeking your advice, what are the biggest things that cause conflict when somebody's maybe leaving a position?
The two biggest areas that I probably focus on is the non-compete and kind of going through what that means and what they can and cannot do and if it's enforceable or not.
Okay.
The other issue is the reason or that the person is told why they're terminated. Is it for cause or not for cause? Because there's a big difference in those two decisions. If it's not for cause, usually there's some sort of parachute where a person may get 6 months or a year of their salary.
Which is part of the employment agreement.
Which is part of the employment agreement,
Okay.
and it's addressed in that agreement. If it's for cause, it generally means that they're not going to get anything. And a lot of times I'll see companies pull that for cause.
Try to say for cause, and that's the source of the conflict.
Absolutely.
Okay.
They'll say it's for cause. They won't pay. They don't want to pay the person anything. And then essentially I have to go in and figure out, was it really for cause? And if it wasn't, then we have to kind of fight that battle.
So how can you, is there a way when you're looking at these agreements at the beginning to try to prevent that from being a conflict later, or is it something you just are forced to deal with if there happens to unfortunately be that situation that arises?
No, I think that when you're signing an agreement or when you're presented with an agreement, you should talk to a lawyer. And for that for-cause provision specifically, you want that as tight as possible. Generally, things you see in a for-cause provision would be no drinking, no arrest. If those things happen, you're going to be terminated. Sometimes
you mean on the job?
On the job,
yeah,
right.
Well, okay.
Sometimes companies will put in not following the directives of the president or some sort of loosey-goosey language that makes it very easy to call what would otherwise be a not for-cause termination a for-cause termination. And the other thing that I always like to put in an agreement is a cure period. 30 days to fix a problem. If the company says to you, hey, Stephen, you're not doing well, you didn't finish these TPS reports, you've got 30 days to fix that problem. Okay.
And if that's not, so if a lot of these things, if you look at an employment agreement and you have an attorney even review it and they're not in the agreement to start with, what are your odds of getting those incorporated before you take a job?
It really depends on the company and the position you're being offered. If it's a large company and you're a low-level manager, more likely than not, you're not going to have the ability to negotiate the agreement the way you want to. If it's a smaller company, or even if it's a large company and you're a very high-level individual, you're going to have a lot more ability to negotiate the terms the way you want them.
That's great. Well, thank you, Todd. I appreciate all those thoughts. Those are really good.
Thanks for having me.